All right. When can police reinitiate interrogation to a suspect who has unambiguously invoked the right to remain silent? My name is Anthony Bandiero, attorney and senior legal instructor for Blue Gold Law Enforcement Training, bringing you another roadside chat. This question comes from an officer in Nevada. So he said, all right, let me kind of move this over here. So he said, I was dispatched to two subjects in a vacant residence, a trailer, who had they broken into it. The neighbor was a 90-year-old man who's been in the neighborhood for a long time. He said, look, the owners of this trailer moved out 3 days ago. Okay, not too long, right? These people that, and then it was a little bit run down. There were some broken windows, but there was a lawful occupant. And the cops called the owner of the trailer and said, hey, there's people in here. And they got permission to enter the trailer and clear it out. So then the cops go in there, they sweep it, they do a protective sweep. They find, a mother and a son in there, like 50 years old. The mom is 50, the son is 30. And they had belongings, clothing, bags, broken drug paraphernalia inside the living room and master bedroom. A records check also revealed that they have been convicted or charged at least several times with unlawful occupancy of a home. The male, while he was being arrested, he said that he had methamphetamine in his right sock. They were both placed in the vehicle. They read Miranda. The son said, I don't want to talk to you at this time. So the officer closed the door for a short time, then reopened the door and began asking questions. The questions were about the occupancy and the drugs we already had PC for. Okay. Was this lawful? No, right? The answer is no. Here's the rules. Okay. Let's lay out some ground rules here. So the first thing is, when is Miranda required under the Fifth Amendment? So Miranda warnings are required when three things are present all at the same time. Number one, the person is in custody. Clearly, this person is in custody. Number two, the person is being asked incriminating questions. What are incriminating questions? These are questions that will foreseeably elicit an incriminating response, meaning these are things that can actually help convict the person. And number three, the person knows that they are talking to a police officer, right? So Miranda does not apply to undercover agents of police. So that's why we have that rule. Okay, well, when does a person invoke their rights under Miranda? When they either A, say they want a lawyer, or B, they just don't want to talk, right? The right to remain silent. Those are the two ways that you can invoke your rights. It has to be unambiguous and unequivocal. That means leaves no doubt, right? So we don't have to consider, like when a person says, maybe I should talk to an attorney, maybe I should talk to my mom before talking to you. Those are not, for the most part, invocations. They're not invoking at that point. They're just expressing uncertainty. That's not unambiguous. The person has to be kind of clear with what they want, because you're not a mind reader. Here, did the person unambiguously invoke the right to silence? Absolutely. They said, I don't want to talk to you at this time. Okay. Does that mean that the door is shut forever? No, you can go back to them. However, there is Michigan versus Mosley, U.S. Supreme Court, 1975, which basically held that you have to scrupulously honor their invocation, okay? In Mosley, the officers got a person who invoked his right to remain silent. Then they went back to him 2 hours later, with a different officer, a different location, about a different crime. And they read him Miranda again. He waived, he confessed, and the Supreme Court says, we're good. Because they did respect his invocation. They didn't browbeat him. They didn't ignore his invocation. They gave him a little time. I like to call it like cooling off period. That's really what I'm kind of looking for. It just give him some time to cool off. Give him some time to think. Give him some time to breathe. Take the pressure off, and then you can go get a waiver later. Now, is it 2 hours required? No, there is no 2 hour rule. If a person invokes the right to remain silent, I have seen cases as little as 15 minutes. Maybe that's what's going on here. I've seen cases overnight, right? The point is, it's based on totality of circumstances. But here, not only do we likely have not a lot of time, because the officer is saying that I close the door, then a short time later, whatever that means, I reopened the door and began questioning. The problem is, even if you don't have a time problem, which you probably do, you still have a waiver problem. I don't see the waiver here. I don't see clear evidence that this suspect actually wanted to waive Miranda. Now, Miranda waivers come in two forms. They come in express and implied. So a very common technique that cops will do is, hey, here's your rights, right? Boom, boom, boom. The rest remain silent. And they'll say something like, okay, do you understand these rights? Yes. Okay. That's not required to say that, but a lot of cops do it and I don't mind it. And then the cop will say, okay, having these rights in mind, do you wish to waive them and talk to me now? And something like that. And the suspect will say, yes. That's an express waiver. That's not the only way you can get a waiver. You can also get an implied waiver, but you still have to prove they wanted to waive, okay? And that you respected their invocation if there was one. So implied waivers kind of look like this. Right to remain silent, blah, 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 lawyer, this and that. Okay, you understand what we're talking about, right? You have any questions about that? No? Okay. What happened, right? And then the person will say, well, she hit me first and this and that. That's an implied waiver. And when you're looking for implied waivers, how do you prove, even though they didn't tell you they wanted to waive, how do you prove that they actually implicitly wanted to waive? Just eager to talk. They cut you off and like, oh, look, I want to tell you my side of the story. I got it. Let me just finish Miranda and we're going to get your side of the story. They easily confess to guilt. No, they seem eager. They're paying attention, native language, all these kind of things, right? They understand their rights. These are all ways or factors that kind of help prove that the person actually wanted to waive their rights. The problem here is, number one, he says he doesn't want to talk, at least at this time. And number two, when the officer went back to him, I still don't see anything about, hey, have you changed your mind? Or, now that you kind of thought about it, do you want to give me your side of the story? I don't see anything that. I just see shutting the door, short time later, opening back up and peppering him with more incriminating questions. Unless I can have more facts on this, I'm not going to be able to uphold it under the Fifth Amendment. So I think that those statements were gotten in violation of Miranda. What does that mean? Does that mean, oh my God, I'm going to civil rights prison? No. What it means is those comments, those admissions are not going to be able to used in that person's criminal trial in the case in chief, which means that the prosecution cannot raise them while they're trying to prove that this person committed these crimes. However, as long as the prosecution does not bring them up, there is no violation of Miranda. So no, we're not violating anybody's rights. Also, just so you know, if the person starts lying about stuff, they're like, well, I never had drugs in my sock, or I never knew that this house did not belong to somebody else. I thought this house was my friend's, and he said I could live at this house, et cetera, et cetera. Then the prosecution can bring up those comments, even despite Miranda, can bring up those comments, say, whoa, isn't it true that you told my officer that you knew that this house did not belong to you, and you just thought since it was unoccupied, you didn't think it was a problem? Well, he got those. I gave him those statements, but he violated Miranda. No, the courts have held that you can still use their comments to impeach them. We're not going to give them a get out of jail free card to lie just because we mess up on some procedure here, right? So as long as it wasn't coerced, and clearly this was not coerced. Coercion means you overcame their free will. Asking these people questions did not overcome their free will. It's a violation, but it's not a coercion issue. Two separate things. It's a procedural issue. At the end of the day, if a person invokes the right to remain silent, you need a cooling off period. How much time that is, I don't know. But factors to look at is change venue, change cop, change crime, something like that. Let some time go by, and that will let you go back to that person and say, hey, can I give you another Miranda waiver, or, and so forth? Can I talk to you again? And then if they say yes, go get that waiver, express or implied, and then go talk to them. Okay? Okay. I hope this helped you understand what's kind of going on here. If you like what we're doing here at Blue to Gold, like, subscribe, share with your friends. And until next time, my friends, you stay safe.